Have you ever been threatened by a council tax enforcement agent demanding payment or even threatening to take your belongings? Here's the truth they hope you never find out. Without a court-issued warrant of control, they have zero lawful authority. Not just a technicality, but it's the foundation of English law. Councils are pushing paperwork that looks official, but legally it's just admin theatrics. Want to protect your rights and push back legally? Stay with me. You need to hear this.
We do our utmost to provide clear, accurate and timely information because we understand just how much this affects your everyday life. In a world awash with noise, spin and half-truths, we're committed to standing firm as a reliable voice you can trust. For us, integrity isn't a buzzword, it's the foundation, and your trust is far more valuable to us than any number of likes or clicks. That said, in a recent video on this very topic, we spotted a few inaccuracies after release. We hold ourselves to a high standard, so we're setting the record straight. Please accept our sincere apologies for any confusion and enjoy this revised version of a subject we believe deserves to be properly understood. Today, you'll learn why council tax enforcement agents, when acting without a valid court-issued warrant of control, have no lawful authority to seize your goods. You'll see how councils rely on administrative paperwork dressed up as court orders, and how the courts and law expose the truth. Council tax enforcement agents are not public officials. They are private contractors, usually self-employed, acting under commercial arrangements with enforcement firms hired by local councils. Despite this, they purport to exercise judicial powers, particularly the power to seize goods. But here's the problem. Those powers only arise when properly triggered under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. And that only happens after a valid warrant of control is issued by a competent court. So, ask yourself this. When have you ever seen an enforcement agent in a council tax matter produce a sealed warrant issued by a court? Never. And there's a reason for that. Schedule 12 of the 2007 Act governs the procedure for taking control of goods to recover a monetary judgment. But those powers are not automatic. They are conditional. Schedule 12, Paragraph 1, Subsection 1 states, using the procedure in this schedule to recover a sum means taking control of goods and selling them to recover that sum in accordance with this schedule and regulations under it. So the process is only available once the power to use it exists. And where does that power come from? Not from a spreadsheet, not from a liability order, not from a council instruction. The power to use Schedule 12 must be lawfully activated by the issue of a warrant of control, and that requires a judgment debt. Under Civil Procedure Rules, Part 84, which governs all enforcement by taking control of goods, the legal framework is clear. Rule 84, Paragraph 1 states, this part contains rules in relation to enforcement by taking control of goods using the procedure in Schedule 12 to the Tribunals, Courts and Enforcement Act 2007. That is only possible when the creditor holds a valid judgment, and only a court can issue a warrant in aid of that judgment. So let's be precise. No judgment means no enforceable debt. No enforceable debt means no lawful warrant. And no lawful warrant means there is no power under Schedule 12. The correct sequence in law is, first, a court of record enters a judgment debt requiring payment of money. Then, the creditor applies for a warrant of control. Next, the court grants the warrant. And lastly, an enforcement agent acts on the basis of that warrant. Without this sequence, there is no authority to enforce. And here lies the central flaw. Council tax liability orders are not judicial judgments. They are administrative entries granted in bulk by magistrates' courts without due process. There is no hearing, no adversarial process, no reasoned judgment, and crucially, no enforceable court order. Regulation 35, Section 3 of the Council Tax, Administration and Enforcement, Regulations 1992, confirms this. It is not to be treated as a sum adjudged to be paid by order of the court. And this means a liability order
is not a judgment debt. It is not a court order, and it cannot support a Schedule 12 warrant. This is not opinion, it is statute. Since the 2003 Amendment Regulations, Statutory Instrument 2003, number 2211, there is no prescribed court form for a liability order. Magistrates' courts do not issue a physical document. At best, the council may obtain a certified extract from the court register, but this is not signed by a judge, contains no reasons, and has no legal standing as an order of the court. The Council Tax Handbook, 13th edition, page 259, and HMCTS guidance confirm this. In R, COFA versus Oldham MBC 2024 EWHC 685, admin, the court considered whether internal council system records were sufficient evidence of a liability order. Fordham J stated, I accept that regulations 34 and 35 contemplate a liability order issued by the court, as opposed to one which is recorded only in internal system records or extracts. Paragraph 12, section 1. This destroys the myth that an internal printout or system log is a valid substitute for a court-issued order. Oldham could not produce such an order. The court upheld the limited scope of the claim, but the legal reasoning is clear. The Local Government Act, 1888, confirms that councils do not exercise judicial power. Section 78, subsection 2 provides, the transfer of powers and duties enacted by this Act shall not authorise any county council to exercise any of the powers of a court of record. And section 79, subsection 2 adds, all duties and liabilities of the inhabitants of a county shall become and be duties and liabilities of the council of such county. That is administrative, and it is not judicial. Some will point to Regulation 45 of the 1992 regulations, which states that where a liability order is made, enforcement may proceed using Schedule 12. But this is not lawful authority. Schedule 12 is not self-executing. It governs how enforcement takes place, not whether it may, and Regulation 45 cannot bypass the need for a court-issued warrant because Parliament never legislated for a new class of judgment debt under the Local Government Finance Act 1992. That means Regulation 45 is ultra vires to the extent it purports to activate Schedule 12 without a valid judicial order. An agent has no authority to act under Schedule 12 unless a valid warrant exists. Schedule 12, paragraph 26, section 1, subsection B, requires an enforcement agent to provide evidence of their authority to act, and that means a court-issued warrant. Without it, they are in breach of statutory duty. They are personally liable for trespass, for entering property without authority, conversion, for interfering with goods, harassment, for threatening seizure without lawful basis, and fraud if they misrepresent their legal standing. Schedule 12, paragraph 66, section 8 provides a defence where the agent reasonably believed the enforcement power was exercisable, but this is an objective test. If the agent has been served with formal notice explaining the legal defects, they cannot plead ignorance. And paragraph 65, section 3 confirms the enforcement agent or a related party has notice of something if he would have found it out, if he had made reasonable inquiries. This means once they are put on notice of the law, their continued enforcement becomes reckless and they lose any statutory protection. Again, once notified of the legal defects in their enforcement action, an agent cannot rely on ignorance. They are personally liable in law, and no firm, no council or policy document can shield them from the consequences. Council tax enforcement agents have no automatic power. You have rights. Demand due process. Demand lawful authority. Refuse intimidation. Stand firm in your constitutional protections, thanks to Wayne Layton and to every man and woman standing up for truth, justice and lawful remedy. There you have it, folks. If this video opened your eyes, imagine how many others are still in the dark. Help them. Like this video, share it with your friends and family, and hit subscribe for more powerful breakdowns on your legal rights. Together, we're cutting through the fiction and shining a light on the truth. Stay informed, stay empowered, and remember, lawful authority must be earned, not assumed. Knowledge is power. Use it. Defend your rights. This video is for educational purposes only. It is not legal advice. You should seek professional legal counsel before acting on any information presented.